Is it possible that someone with a grudge against you may want to get even with you someday? What if that person could get you swatted, having armed police come to your door with the potential of harming you or your family, someone actually getting shot? What I'm going to show you right now is not an exaggeration as we approach the approval of this terrible Bill C-21.
Police, search warrant, open the door! Open the door! Now! Yo! Open the door now, open the door now. Open the door. Open the door, ma'am. Open it now. I'm outside. Look, in the house now.
My 2 children and my husband.
Calm down. Calm down.
You want the children down?
All down.
What is that?
Police, come down now.
Do not point that gun at my children! You just pointed a gun at my children!
Hello and welcome back to the Waiting Native Chronicles. What you've just seen is what is a real possibility of happening to many Canadians in this country due to the provisions in this new Bill C-21. What can happen to you is that you can have a person go straight to the court and speak to a judge ex parte, which means in secret, with no one in there to challenge their accusations, not even the police. And that person can create a false story about you and say that this person is dangerous and he needs to have the police go and get his guns from him right away. That's when the police will come right to your door. Person can do that without any fear of repercussions, not even disclosing his identity. Not only that, the police won't even be involved because they aren't able to attend this hearing. Normally what police can do is they can look into this person and say, oh, this person has done this sort of thing before, or they have a special grudge against this person. Things like that. Anything, is this person even the person he claims to be? But what's going to happen as a result of this BC-21 is that the judge is going to hear that person's complaint, and to be on the safe side, what he's going to do is he's going to grant that order. It's going to be an order that results in the police coming to your door armed with AR-15s and such, 5 or 6 or 7 or 8 police, and they're going to come through your door just like we saw in this video here. This is an atrocious situation, but it gets worse. Not only will that person be able to conduct this trial in secret with no public input, the judge can also state that no one is allowed from the public to even attend the trial, and you are not able to challenge it. You're not even able to find out who that person was who laid this scurrilous accusation against you. There are so many opportunities for abuse in this law, and this goes totally against all our traditions of law, where you have a right to challenge your accuser, and you should have a right to clear your name. That's where it gets even worse. I'm not exaggerating about this, folks. It gets even worse. Because as we're going to see in this video, once such a scurrilous charge is placed against you, it's put in place for 30 days and then it's reviewed. So fortunately, it lasts for 30 days. The police can look into it. You can speak to the court about it and point out, that there's some lies involved, whatever, and get the whole thing revoked. But that's not where it ends. As a result of BC-21, what's going to happen, and I will show you this in the text of the proposed legislation. This is no exaggeration. The fact that you did have this order placed against you, even though it was overturned, makes absolutely no difference. No difference at all, in the sense that you will be prohibited from owning firearms for the rest of your life. Think about that. There is no recourse for you. The law is gone, shoved under the rug. And nobody's going to complain about this because it's just going to be applied to gun owners. We're the bad guys anyways, so I guess we don't deserve any protection by law. We're going to be completely open to abuse under this new system. This is the worst aspect of the Bill C-21 proposed legislation possible. By far, it outstrips everything else, and there's a lot else bad in it, as I've covered in other videos. So what I'm going to do for you in this video, I'm going to show you from the letter of the proposed legislation, black and white, where it actually says what I'm telling you right now is going to happen. Okay, shall we get into this? Let's take a look first at the Act being amended for Section 110, Application for Emergency Prohibition Order. You can see that on your screen right now. It says that any person may make an ex parte application. That means that they can go by themselves to the judge. They don't have to go to the police anymore like they used to. And then the police sort of vet their complaint. No, they go straight to the judge by themselves without you standing in defense of yourself. Not even the police there. That person makes an ex parte application to a provincial court judge for an order prohibiting another person from possessing any firearm, crossbow, prohibited weapon, restricted weapon, prohibited device, ammunition, prohibited ammunition, or explosive substance, or all such things if the person believes on reasonable grounds that it is not desirable in the interests of the safety of the person against whom the order is sought, or if any other person that the person against whom the order is sought should possess any such thing. Let's carry on to part 2. Hearing in private. The provincial court judge may hold a hearing of an application made under subsection 1 in private if the judge considers that it is necessary to protect the security of the applicant or of anyone known to the applicant. This is also going to result in the fact that even after all the dust settles and it's found to be false or fake, that you will still maybe not even know who the person is that requested this order and made this false charge. Crazy. Okay, let's move on. Let's move on to the order denying access to information. Just like I was saying, nobody's going to know. There's no repercussions. 110.2. If an order is made under subsection 110.1, the provincial judge may, on application by the person who applied for the order or on the judge's own motion, if the judge considers that it is necessary to protect the security of the person or of anyone known to the person, make an order prohibiting access to and the disclosure of any of the following: any information related to the order made under that subsection, any information relating to the warrant issued under that subsection, any information related to a search and seizure conducted without a warrant under subsection, any information relating to the order made under the subsection. So, did you notice that little part about the warrant with the seizure without warrant? We'll get into that too. No, they're not going to need a warrant anymore either, folks. There's so much to cover in this. It's actually hard to believe this can take place in our Canadian system. But apparently, gun owners are so bad that no overreach of government is unjustified in our case. But all of you who aren't gun owners, be careful. There's precedents being set here. We already saw it with a truckers' convoy when they went right into their bank accounts and froze their money. Never saw that before either, did you? Once it's done once, the government will keep on going, taking another step, and another step, and it won't be applied to just the one group. It's going to start being applied to other people because they know they can get away with it. We're just being cowed into submission here, people. Okay, so that is showing where we're having these secret meetings, trials. Normally, you know, the public is supposed to be able to see trials because to make sure that things are being done right. Because if there's some abuses occurring, there may even be a publication ban on the trial so that you can't publish it in the newspaper or something like that. There are cases like that where it's justified in the case of children and things like that. But this is not even allowing the public to attend the trial. Even with cases where you have a publication ban, the public is still allowed. You can just go to the courtroom and you can sit in there and you can watch the proceedings. It's that transparency that ensures that abuses don't happen. That is so important to our system of law in Canada and any country. Unbelievable. Okay, let's carry on here about the Emergency Prohibition Order. If at the conclusion of a hearing, an application made under subsection 1, the provincial court judge is satisfied that the circumstances referred to in that subsection exist, and that an order should be made without delay to ensure the immediate protection of any person, the judge shall make an order prohibiting the person against whom the order is sought from possessing any firearm, crossbow, blah, 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 for a period not exceeding 30 days as specified in the order, beginning on the day on which the order is made. Okay, so that's what happens, right? We're going to circle back to this too in a few minutes. But the initial order is for 30 days because initially the judge is going to make the order, but it hasn't really been vetted by the police, and the person who's being charged hasn't been able to defend themselves, but they're trying to get things going right away. You can sort of see that. But it's all ex parte. You don't even know you're being charged. And there's another repercussion that's coming from this. As we're going to see later, there is also another change in Bill C-21, that the fact that he did this for 30 days, even if it's overturned, revoked later on, you are still never ever going to be able to have the right to own a firearm again. You'll lose your PAL. This is crazy, because everything is working against us in this. Just think about this for a minute, because what the pressure is on the judge is they're thinking, well, somebody could get killed. If I'm wrong, something bad can happen. That's going to be blowback on me. So the safe route is, okay, let's give this an emergency protection order and put it. It's only going to be for 30 days. Going to be reviewed later on anyways. That's when the police get involved and they look into what's going on, and the person being charged can defend themselves and give their side of the story. We're going to sort it out later on anyways. But that's no good, because according to this new legislation, and I'm going to read it to you in black and white. According to this new legislation, the fact that if you have a protection order against you, or ever have had one in the past, in your entire life, you're not going to get a PAL anymore. It's going to be yanked from you once this legislation passes. This is absolutely incredible. Let's move on to the next one here. I just want to cover this part about the warrant to search and seize. Normally a judge issues a warrant, but according to this new legislation, the police aren't even going to need a warrant. Read this. Warrant to search and seize. If a provincial judge is satisfied by information, let's see. Now that's the warrant to search and seize. This is how it works from the judge's end. If he's satisfied there's enough reasonable grounds, then he issues a warrant to search and seize. Let's move on to the next one here. It's not just a judge who can do it. No. if in respect of a person who is subject to an order made under subsection 3, a peace officer is satisfied that there is reasonable grounds to believe that it is not desirable in the interests of the safety of the person or any other person for the person to possess anything the possession of which is prohibited by the order, the peace officer may, if the grounds for obtaining a warrant under subsection exist, but by reason of a possible danger to the safety of the person or any other person, it would not be practical to obtain a warrant, search for and seize any such thing and any authorization, license, or registration certificate relating to any such thing that is held by or in possession of the person. So they don't even need a search warrant. If the police officer thinks that it's reasonable grounds, in he goes. They're going to come in, banging on your door, kicking it in, perhaps. AR-15s at the ready. Several police officers pointing them at you. Not just you and your family, your children, your wife, or if you're female, your husband. Things can go wrong in scenarios like that. Somebody somewhere down the line is going to get shot by this, because when you don't know what the person accusing you has said to the judge. They might have said crazy things like that you're ready to kill anyone who walks through the door. You're not going to ever submit to them or something like that. That you're absolutely batshit crazy, and they better be ready because you're going to shoot them. It's the story being told them. You have no idea how you can't protect yourself in any way. So if you make just the wrong move, say the wrong thing, or someone in your family makes the wrong move, they think they're going for a gun or something like that, bang, they're going to be shot right away. Somebody will get killed as a result of this. But it's only gun owners, so I guess it doesn't matter because they're all trying to protect us, right? Okay, let's just carry on here. Now I want to just show you, we'll get to the conclusion of this. I want to show you, I think this part here is what I was saying in black and white. I want you to see all this yourself. I'm going to put links to these documents in the description of this video so you can see them for yourself. This is not hidden. Of course, the mainstream media is never going to cover this, but I will. Here we have 15 subsection 2.1 being amended by adding the following. Protection order. Now, protection order, you have to understand that correctly. They're saying here that it's the meaning of that term is going to be assigned in the regulations, but I have it on good authority that the definition of protection order is going to include what we talked about before, the Emergency Prohibition Order, where the ex parte appearance before a judge occurs. So this is all applying to that as well. And it's going to apply to peace bonds. So I'm talking to a whole bunch of people with a wide variety of experiences here right now, okay? You were, maybe you're old now, you were a young person at one time, maybe you had a big argument one time, maybe you had a really bad breakup with an ex-partner, maybe you had a business deal go really south, maybe you're a police officer who arrested somebody who really wants to get at you. But if you had a peace order placed against you, that's usually done because the Crown can't really make a case to successfully prosecute you. So instead of going through multi-$1,000s of court costs with lawyers and all that, they can offer you, okay, we're not going to charge you, but we're going to give you a peace order that you have to abide by. Well, peace orders are also included under this. Think about this, folks. How many of you have never made a mistake in your life or never had a dispute with anybody, even if it was 20 years ago, or never will in the future? This can affect a lot of people who are bosses, people in authority. Maybe you let somebody go and they really don't like you after that. Once they learn about this law, they can really get you. They know you like guns, or that you have guns, or maybe that you have a nice collection, whatever. If they really want to get you where it hurts, all they have to do is get this Emergency Prohibition Order. They won't even be accountable for it. You may not even know who placed that order. And the court may say it is not allowed to be disclosed. Not even the public will be able to attend that court session. And here you are, now you are screwed for the rest of your life. No recourse, no legal recourse, and I really mean that. No recourse at all. When did this happen to this country? When did things change where we could suddenly do things like this? Where people could be falsely accused and suffer for the rest of their life as a result of that false accusation, never ever being able to redeem themselves, even after found innocent. This is absolute insanity. Cover this last section here. Protection orders, subject to 7003 and regulations, an individual is not eligible to hold a license if they were subject to a protection order. And that's what we're talking about, our PALs and RPALs. So, you know, I'm not one that's given to hyperbole. I don't like to exaggerate things. But I find myself in the unfortunate situation today of telling you that this dystopian future is upon us. And we have to fight hard. I don't mean violence, I just mean we have to exercise our rights as Canadians to the absolute maximum. And that includes getting organized. And writing to your MP. There has to be a huge hue and outcry in this country. And we have to put a stop to this out of control Prime Minister who disregards anyone who disagrees with him as having unacceptable views, having no rights. Maybe he'll be calling us Nazis next too, right? So I hope you take this under advisement. This is the Way to Native Chronicles, and signing out, and I'm wishing you God bless, and catch you next time.
All down.
What is that?
Come down there. Yeah. Come over here. Police, come down now.
Do not point that gun at my children! He just pointed a gun at my children!
Yide to senela ke kehotse te. Ike datse te kehotse.